Hello, everybody. I'm back. It's good to see you here, although no people are looking at me right now. I hope this is working. My name is Gerald Smimmons. Part 2 of this. Okay. I'm not getting anybody on here. Let me just smack you guys with one of these 30-minute countdowners. Bye. Okay, we are back from the tornado that almost blew my sweet ass away. It almost blew my sweet wild ass speculations into the next county. You see what I go through for you people? Do you see what I go through? I'd like to say hello to Backseat Gamer. Hello, she's the first person back. We got 4 people watching right now. What happened? Forget about me. I'm fine. Although my SD card in my mixer has seen better days. I might have lost some audio on that one, but that's okay. Laura's back. Electra is back. Electra held it down during the tornado party. There's still a tornado advisory till 11 o'clock and a thunderstorm warning is 8:44 here. I can stay on until 10 o'clock, but it is not over my immediate vicinity. So I'm all right. All right. So what do we got? We just got some... I don't know how many of you were listening to Electra when she was live on the radio just now talking about the Idaho 4 documents that just dropped, which I just started reading before I got kicked off. And I'm going to start reading it again. Let's just go ahead and go into it. I'll start right where I dropped off. I was listening to Electra, and I was shocked for the Gonsalves family. And we're talking about the dissemination order. The ruling came down as we were live. We started reading it. Hello, Boss Macca. Haven't seen you in a while. Glad you could make it. For this tornado edition of Midnight Radio. Okay, I'm trying to find right here. All right, we're talking about these documents that just dropped from Idaho, courtesy of Ann Taylor. Actually, it's not Ann Taylor. This came from the judge himself. Why? Because he's the one that ruled on this. The other one that dropped was about, I don't know, slowing something down, making it shorter for Bryan. All right. This order addresses a motion to vacate the amended non-dissemination order filed by Interveners, the coalition of 20 media outlets that will be collectively, including Midnight Radio, that will be collectively referred to as the Associated Press. The amended non-dissemination order does not restrict, it does not restrain, or in any other way enjoin press from reporting on and public information. Well, hold on a second. Let me try something. Let me try something that might make it better here for me. For me alone. No, it does not. All right. Let me continue here. The amended non-dissemination order does not restrict, restrain, or in any other way enjoin the press from reporting on or publishing information they obtain through their own investigations or interviews. Again, it's not for the press, supposedly. Even bullshit. You can say bullshit. All right. Lies are covered under the First Amendment. They actually are. Disinformation is too, right? Is it? Is it not? I got some really good, interesting footage about the alien UFO in Vegas. All right. So the fact that the government can lie, it's okay, but reporters can't. Actually, they can. The amended non-dissemination order is not a gag order on the media. Instead, the amended non-dissemination order restricts attorneys directly involved in the case who are representing a party, a witness, or a victim's family, and the agents for those attorneys, including law enforcement, for making certain statements about the case to the media or the public, because membership in the bar is a privilege burdened with conditions. The U.S. Supreme Court has recognized that the speech of lawyers representing clients in pending cases may be regulated under a less demanding standard than the established for regulation of the press. Again, I'll say it again, and this is important to think about. The U.S. Supreme Court has recognized that the speech of lawyers representing clients in pending cases may be regulated under a less demanding standard. As officers of the court, court personnel and attorneys have a fiduciary responsibility not to engage in public debate that will redound to the detriment of the accused or that will obstruct the fair administration of justice. Where do you guys think this is going so far? All right. I'm seeing alibis from the part of the judge saying why he's going to, all right, shut down why this gag order, which I don't care what they want me to call it. I'm calling it a gag order. Freedom of the press gag order, because it makes me want to puke. All right. They're hitting it with a hammer. They're going to make it hurt. The purpose of the amended non-dissemination order, which was stipulated to by the parties, is to protect defendant Bryan C. Kohberger's right to a fair trial by an impartial jury as guaranteed by the Sixth Amendment. But let me tell you what's real here, okay? It is not just about Bryan Kohberger, okay? And nothing hit this more home to me today than I was looking at the judge for the Parkland shooter trial. Remember him? And the judge was going over that. I think I might bring that up after this, because that judge is looking like a real asshole right now, because some of the things she said and some of the things she did during the trial, specifically an exchange she had with one of the lead in the defendant's lead about her son and her children and the way they were speaking back and forth, and she ejected him from the courtroom, which was not in her power to be able to do, not for the reasons that she did it. All right, she looked like a real jerk. So if you don't go by certain rules and what you're allowed to do, you look like an asshole from a court above you when they can remove you from the bench and a whole lot of other things. So it is better as a judge. You got a cushy job. It's not easy. All right. A lot of paperwork and other bull crap you got to deal with. And then, I mean, you're not dealing with the most nice people in the world. You got to deal with, lawyers and criminals in a hot ass room all the time with these high ceilings. You know, they can't air condition that, right? You've been there in the jury pool. But you don't want to look like a jackass. So that is what this is about. The Associated Press's motion to vacate the amended non-dissemination order is denied. The capital D. The court has the authority to regulate the speech of attorneys participating in this case and the agents for those attorneys to ensure that poor little Bryan Kohberger is not denied his right to a fair trial by an impartial jury because of extrajudicial prejudicial statements. However, this court will issue a revised amended non-dissemination order that clarifies what cannot be discussed and what can be discussed. If you remember, that was an issue before. They would not talk about anything relating to anything, and they were blaming it on the Kohberger trial. But now they're not going to be able to do that. Supposedly, that's what this says. The revised amended non-dissemination order is limited to apply only to speech that is substantially likely to have a material prejudicial effect on the right to a fair trial. 2, applies equally to all attorneys participating in the case. 3, is neutral as to points of view. And 4, restricts attorneys' comments only until after the trial and by sentencing proceedings that may take place. The revised amended non-dissemination order is reasonable considering the facts of this case. One, the evidence presented by the defense showing the pervasiveness of media coverage, including coverage prejudicial to Kohberger and coverage that includes extrajudicial statements by an attorney participating in this case, and the impact such prejudicial news coverage has on potential jurors and the fair administration of justice. The restriction imposed serves a legitimate purpose, and the very limiting incidental effects of the revised amended non-dissemination order on the media's First Amendment rights are overridden by the compelling interest in ensuring that Kohberger's right to a fair trial under the Sixth Amendment is not jeopardized. On November 13th, 2022, 4 University of Idaho students, Kayla Gonsalves, Madison Mogan, Xana Kernodle, and Ethan Chapin, were found deceased in Gonsalves, Mogan, and Kernodle's off-campus home in Moscow, Idaho. The cause of death for each was ruled a homicide as news of the tragedy broke. Media outlets from around the country descended upon Moscow as law enforcement investigated. News stations, newspapers, and social media were flooded with stories and speculation about the homicides and law enforcement's investigative efforts and abilities. Throughout the course of the investigation, the Moscow Police Department, in partnership with the University of Idaho and Latah County Prosecutor's Office and the Idaho State Police, held press briefings to answer questions and reassure the public. Appropriately, the information released was limited to protect the integrity of the ongoing investigation, which doesn't happen in other states, Judge. On December 30th, 2022, Kohberger was arrested and charged with 4 counts of murder in the first degree and 1 count of burglary. Again, media outlets descended upon Moscow, and the news coverage quickly focused on Nothingburger. The same day that Nothingburger was charged, his attorney filed a motion for non-dissemination order asking the magistrate judge to enter an order barring parties, their attorneys, investigators, law enforcement personnel, and potential witnesses from discussing the case with any public communications media. Thereafter, on January 3rd, 2023, the defense and the state filed a stipulation for non-dissemination order prohibiting attorneys, investigators, and law enforcement personnel from making any extrajudicial statements, written or oral, concerning this case, other than a quotation from or reference to, without comment, the public records of the court in this case. The same day, the magistrate judge entered a non-dissemination order prohibiting the parties to the case, including investigators, law enforcement personnel, attorneys, and agents of the prosecuting attorney or defense attorney, for making extrajudicial statements, written or oral, concerning this case, other than a quotation from or reference to, without comment, to the public records of the case. But on January 13th, 2023, the magistrate judge held an in-chambers off-the-record conference, which they like to go off the record there in Idaho, with Latah County Prosecuting Attorney William H. Thompson, Jr., Senior Deputy Prosecutor Ashley S. Jennings, Defense Counsel Ann C. Taylor, attorneys for 2 witnesses in the case, and Shannon Gray, attorney for the Gonsalves family. A summary of the meeting as prepared by the parties in this case was filed with the Idaho Supreme Court on March 3rd, 2023, as part of the declaration of Deborah A. Ferguson. That sounds like a damn horror movie. In the case of Henry petition of writ for mandums of writ of prohibition. The purpose of the conference was to address the applicability of the non-dissemination order to the attorneys both present as parties to the case and the attorneys participating in the case. The magistrate judge reminded the attorneys that this case is a high-profile case with both national and international media coverage, and that they have a duty under the Idaho Rules of Professional Conduct to not interfere with the party's right to a fair trial. The magistrate advised the attorneys that it was not their job to disseminate information to the media. The magistrate judge stated that the non-dissemination order did not restrict the attorney's non-party clients' from speaking to the media, but reiterated the importance of the case being tried in a court of law and not the media, and encouraged each attorney to advise their clients accordingly in order to preserve the right to a fair trial by an impartial jury. On January 18th, the magistrate judge, based on the stipulation of the parties, entered the amended non-dissemination order to balance Kohberger's and the state's right to a fair trial and the right to free expression as afforded under both the United States and Idaho Constitution. The magistrate noted that to preserve the right to a fair trial, some curtailment of the dissemination of information in this case is necessary and authorized under the law. So the non-dissemination order reads as follows. The attorney for any interested party in this case, including the prosecuting attorney, defense attorney, and any attorney representing a witness, victim or family, victim's family, as well as the parties to the above entitled action, including but not limited to investigators, law enforcement personnel, and agents for the prosecuting attorney or defense attorney, are prohibited from making extrajudicial statements, written or oral, concerning this case except without additional comment, a quotation from, or reference to the official public record of the case. This order specifically prohibits any statements which a reasonable person would expect to be disseminated by means of public communication that relates to the following: evidence regarding the occurrences or transactions involved in this case, the character, credibility, reputation, or criminal records of a party, victim, or witness, or the identifying of a witness, or the expected testimony of a party, victim, or witness. This is exactly what we talk about here on the Free Press every day. The performance results of any examination or test, or the refusal or failure of a person to submit to an examination or test, any opinion as to the merits of the case, or the claims or defense of a party, any information a lawyer knows or reasonably should know is likely to be inadmissible as evidence in a trial, and that would, if disclosed, create a substantial risk of prejudicing an impartial trial. Any information reasonably likely to interfere with the trial in this case afforded under the United States and the Idaho Constitution, such as the existence or contents of any confession, admission, or statements given to the defendant by the possibility of a plea of guilt, or any opinion as to the defendant's guilt or innocence. On February 6, 2023, the Associated Press filed a petition for writ of mandamus, or a writ of prohibition, with the Idaho Supreme Court related to the amended non-dissemination order on April 24th, 2023. Idaho Supreme Court issued an opinion dismissing the Associated Press's petition, finding that although the media did have standing challenge to the amended non-dissemination order, they must first present their petition to the trial court. Thereafter, on May 2nd, 2023, the Associated Press filed a motion to intervene and a motion to vacate the amended non-dissemination order. The magistrate set a scheduling conference for May 22nd, 2023, and you all watched it right here on Midnight Radio. On May 16th, 2023, a surprise indictment was filed against Nothingberger, and this court began presiding over the case. On May 22nd, 2023, after Kohberger's arraignment, this court conducted a scheduling conference. It set a briefing schedule and hearing for oral argument. The Associated Press's motion to vacate the amended non-dissemination order was extensively briefed, and both the state and Kohberger submitted extensive briefing in opposition to the motion. Oral arguments were heard on June 9th, 2023. The state was represented by William H. Thompson, Jr. and Bradley J. Rudley, Latah County Prosecutor's Office. Kohberger was represented by Nancy Taylor, J.W. Logson, Kootenai County Public Defender's Office. The Associated Press was represented by Wendy Olson and Corey Carone. During the hearing, The defense put on the testimony of two expert witnesses. First, Gene R. Saucier, Senior Vice President of Truth Scope North America, testified. In sum, Mr. Saucier testified to the quantity of media coverage in this case. It is undisputed that media coverage in this case is rampant and ongoing, kind of like a rash, including on television, the internet, social media, and the radio. I'm doing two of those right now. News surrounding the case is being reported by reliable sources of news, unreliable news outlets, and individuals engaged in spreading or fueling rumors, otherwise known as smackerjackers. Theories and unfounded speculations. They should have said wild ass theories, and when you would have known who they were talking about. It is also worth noting that Mr. Saucier's testimony and the exhibits she showed, I wonder if who else she talked about in that, demonstrate that in the share of voice media coverage category, Shannon Gray's stories in the media had the highest potential reach at 561,102,573 impressions, with impressions being the opportunities to see a story. Exhibit A, to defendant's objection to media's mot to vacate the amended non-dissemination order. Shannon Gray is the attorney for the Gonsalves family and is bound by the amended non-dissemination order. In other words, he is shut down. The defense also submitted several news articles demonstrating that at least some portion of the news, if not most of it, is prejudicial to Kohberger. See motion to take judicial notice of press coverage. Second, Dr. Emal A. Alai, social psychologist and social cognition researcher, testified to the impact social media can have on a potential juror. It was Dr. El Alai's opinion that vacating the non-dissemination order would increase the potential for bias among prospective jurors, both initially and throughout the trial. Dr. El Alai further opinion that my review of research illustrates that the anti-defendant pretrial publicity increases the probability of guilty verdicts, and that this bias persists despite the receipt of trial arguments, evidence, admonitions to disregard the publicity, information, and jury deliberation. Commentary by individuals with status/expertise, like police, attorneys, and judges, in media coverage create more potential for biased jurors. Example D, to defendant's objection to media's MOT, to vacate the amended non-dissemination order. 3, issues presented. The Associated Press argues that the amended non-dissemination order restrains their constitutional right to gather news before it can be exercised, in violation of the First Amendment, mem and sup of Mo, which is motion. To vacate the amended non-dissemination order at 15, the Associated Press asserts that their First Amendment rights are being violated. I feel also violated. The media does not make the news. It reports the news. ID 17. The argument continues that if a court orders an individual not to provide information to the media, then the media has nothing to report. Interveners. Speech is thus being restrained before they can even speak. 15. Thus, the Associated Press alleges that the amended non-dissemination order is a prior restraint on the media and does not survive the strict scrutiny test applied to prior restraints on the press. In other words, it doesn't survive the smell test. It smells like ass. This decision addresses the following. 1, the obligation of the court to ensure that Kohberger's right to a fair trial is not being jeopardized by extrajudicial statements. 2, the court's authority to impose restrictions on the speech of those attorneys and their agents involved in this case. And 3, the standard applied to reviewing constitutional challenges by the media to non-dissemination orders aimed at pretrial participants, especially lawyers. Finally, this decision applies to the law to the facts of this case in addressing the Associated Press's argument that the amended non-dissemination order violates their First Amendment rights. Yes, it does. but you better enjoy the violation. That is what I'm reading here, because that is what's going to happen. In 1966, the U.S. Supreme Court recognized the defendant's right to a trial by an impartial jury free from outside influences in the face of massive, pervasive, and prejudicial publicity. While recognizing that a responsible press has always been regarded as a handmaiden of effective judicial administration, especially in the criminal field, the court chastened the trial judge for not taking strong measures to ensure Shepard's right to a fair trial in 1522. In Shepard, there was not a dissemination order on trial participants or any gag order in the media. Notably, in overturning Shepard's conviction, the court listed several things that the trial should have done. The trial should have adopted stricter rules governing the use of the courtroom by newsmen and should have more closely regulated the conduct of newsmen in the courtroom. Look, let's go back at one of adopted stricter rules governing the use of the courtroom by the newsmen in the courtroom, the newsmen in there. The court should have insulated the witnesses. All the newspapers and radio stations apparently interviewed prospective witnesses at will and in many instances disclosed their testimony. 3, the court should have made some effort to control the release of leads, information, and gossip to the press by police officers, witnesses, and the counsel for both sides. Much of the information thus disclosed was inaccurate, leading to groundless rumors and confusing. Sound familiar, everybody? The judge should have at least warned the newspapers to check the accuracy of their accounts. And 5, it is obvious that the judge should have further sought to alleviate inaccurate, prejudicial news by imposing controls over the statements made to the news media by counsel, witnesses, and especially the coroner and police officers. In summary, the court stated that the trial court might well have prescribed extrajudicial statements by any lawyer, party, witness. Extrajudicial, that's hard for me to say, guys, when I'm talking live on the radio. I'm going to read that again. In summary, the court stated that the trial might well have prescribed extrajudicial. I got to say it. If I say it like I'm angry, I'm all right. Extrajudicial statements by any lawyer, party, witness, or court official which divulge prejudicial matters such as the refusal of Shepard to submit to interrogation or take any lie detector test, the identity of prospective witnesses or their probable testimony, any belief in guilt or innocence, or like statements concerning the merits of the case. In this manner, Shepard's right to a trial free from outside influence would have been given added protection. Without corresponding curtailment of the news media, had the judge, the other officers of the court, and the police place the interest of justice first, the news media would have soon learned to be content with the task of reporting the cases that unfolded in the courtroom, not pieced together from extrajudicial statements. In other words, they would have learned to sit down, shut up, and to take it like a man. In addressing the tension between the First Amendment and the Sixth Amendment, the court stated this. From the cases coming here, we note that unfair and prejudicial news comments on pending trials has become increasingly prevalent. Due process requires that the accused receive a trial by an impartial jury, free from outside influences. Given the pervasiveness of modern communications, any asshole can get on YouTube and on the radio and say whatever he wants. I just added that. But isn't it true? Given the pervasiveness of modern communications and the difficulty of effacing prejudicial publicity from the minds of the jurors, the trial courts must take strong measures to ensure that the balance is never weighed against the accused. And appellate tribunals have the duty to make an independent evaluation of the circumstances. Of course, there's nothing that prescribes the press from reporting events that transpire in the courtroom, but where there is a reasonable likelihood that prejudicial news prior to trial will prevent a fair trial, the judge should continue the case until the threat abates. or transfer it to another county, so not so permeated with publicity. In addition, sequestration of the jury was something the judge should have raised sua sponte with counsel. If publicity during the proceedings threatens the fairness of the trial, a new trial should be ordered, but we must remember that reversals are but palliatives. The cure lies in those remedial measures that will prevent the prejudice at its inception. The courts must take such steps by rule and regulation that will protect their processes from prejudicial outside influences. Neither prosecutors, counsel for defense, the accused, witnesses, court staff, or enforcement officers coming under the jurisdiction of the court should be permitted to frustrate its function. Collaboration between counsel and the press as to information affecting the fairness of a criminal trial is not only subject to regulation, but is highly censurable and worthy of disciplinary measures. Now, the Associated Press relies heavily on CBS Incorporated versus Young from 1975 in support of their position that the amended non-dissemination order is unconstitutional and must be vacated. In that case, the appellate court issued a decision addressing a non-dissemination order entered in a civil case. There, the non-dissemination order prohibited all counsel and court personnel, all parties concerned with its litigation, whether plaintiffs or defendants, their relatives, close friends, and associates, from discussing in any manner whatsoever these cases with members of the news, media, or the public. The press challenged the order as violating the press's rights under the First Amendment. The court held as follows: before a trial court can limit defendants and their attorneys' exercise of First Amendment rights of freedom of speech, the record must contain sufficient specific findings by the trial court establishing that defendants and their attorneys' conduct is a serious and imminent threat to the administration of justice. Craig versus Harney. 1947. Applying either the standard that the speech must create a clear and present danger, Wood versus Georgia, 1962, of a serious and imminent threat to the administration of justice, or the lesser standard that there must be a reasonable likelihood, United States versus Teherana, I'm murdering that one, 1969, of a serious and imminent threat to the administration of justice, we hold that the trial court's order is constitutionally impermissible. However, the court reasoned that the order issued by the trial court constituted a prior direct restraint upon freedom of expression in sweeping terms that seals the lips of all parties concerned with this litigation, whether plaintiffs or defendants, their relatives, close friends, and associates, bankers, grocery sackers, from discussing in any manner whatsoever these cases with members of the news media or the public. Although the news media are not directly enjoined from discussing the case, it is apparent that significant and meaningful sources of information concerning the case are effectively removed from them and their representatives, to the extent that their protected right to obtain information concerning the trial is curtailed and impaired. The court continued, we find the order to be an extreme example of a prior restraint upon freedom of speech and expression, and one that cannot escape the prescriptions of the First Amendment unless it is shown to have been required to obviate the serious and imminent threats to the fairness and integrity of the trial. Order denying the Associated Press's motion to vacate the amended non-dissemination order. In this court's view, the Young's court reliance on the high standard applied in Craig versus Harney or Wood versus Georgia is misplaced. Both of these cases dealt with contempt proceedings and did not address non-dissemination orders restricting extrajudicial statements by specific persons to preserve the right to a fair trial. In Harney, 3 media personnel were found guilty of criminal contempt and sentenced to 3 days in jail for publications during an ongoing civil case in which they criticized the presiding judge. The judge found the news reports were designed to falsely represent to the public the nature of the proceedings and to prejudice and influence the court to grant a new trial. In reversing the decision of the trial court, the court held that giving the editorial all the vehemence with which the court below found in it will fail to see how it could in any realistic sense create an imminent and serious threat to the ability of the court to give fair consideration to the motion for the hearing. In Harney, this court agrees that any attempt by court to hold the media in contempt and even jail them for publications critical of the court should be viewed under the strictest scrutiny. However, the facts in Harney have no similarity to the restriction on the speech of trial participants in the case or in the Young case. In Wood, a grand jury was impaneled and instructed by the court to investigate a voting issue within the county. While the grand jury was in session, the elected sheriff issued a public statement criticizing the judge for singling out the African-American community and essentially attempting through the judicial process to intimidate and silence the African-American vote. The sheriff also wrote a letter to the grand jury implying that the court's charge was false. Among other things, a month later, the sheriff was cited for contempt following a trial where the court failed to make any findings or articulate any reasonings for its decision. The sheriff was found guilty of contempt and sentenced to 20 days in jail. In overturning the contempt conviction, the Supreme Court held that as an elected official, the sheriff had the right to enter the field of political controversy, particularly where his political life is at stake. The role that elected officials play in our society makes it all the more imperative that they be allowed freely to express themselves on a matter of current public importance. Our examination of the content of petitioners' statements and circumstances under which they were published leads us, the sick, conclude that they did not present a danger to the administration of justice that would vitalize interesting choice of words. Vital his freedom to express his opinions in the chosen Wood case 394-95. Again, the facts in Wood have no similarities to the amended non-dissemination order. To this case or in the facts of Young. Additionally, the Young's court's findings that before trial, court can limit defendants and their attorneys' exercise of First Amendment rights to freedom of speech. The record must contain sufficient specific findings by the trial court establishing that defendants and their attorneys' conduct is a serious and imminent threat to the administration of justice. Is at odds with the Supreme Court's later holding in Gentile. That will be discussed below, but see Levine versus U.S. District of California, 1985. The trial court imposed a restraining order prohibiting attorneys involved in this case from communicating with the media regarding the merits of the case. In reviewing the restraining order, the Ninth Circuit applied strict scrutiny, regardless of the standard applied to a constitutional challenge by a lawyer restricted by a non-dissemination order. A less demanding standard is applied when the media challenges such an order. Radio and Television News Associations of Southern California versus U.S. District of Connecticut, Center, California, 1986. In 1976, the U.S. Supreme Court again addressed the tensions between the First Amendment and the Sixth Amendment in Nebraska. Press Association versus the court in 1976. Even then, in 1976, the court acknowledged that the speed of communication and the pervasiveness of the modern news media have exacerbated the tension between the First Amendment and the Sixth Amendment. Unlike in this case, Nebraska press dealt with a restraint in the media's ability to publish or broadcast specific information. For example, a restraint on freedom of the press and not a restraint on freedom of speech. The court recognized that when the case is a sensational one, tensions develop between the right of the accused to trial by an impartial jury and the rights guaranteed others by the First Amendment. The court noted that a prior restraint on speech is most serious and the least tolerable infringement on the First Amendment rights. while also acknowledging that when the death penalty is on the table, it is not required too much that a defendant be tried in an atmosphere undisturbed by so huge a wave of public passion. In Irwin versus Dowd, 1961, the court stated, asking too much to suggest those who exercise First Amendment rights in newspapers or broadcasting enterprises direct some effort to protect the rights of an accused to a fair trial by unbiased jurors. You know, the funny part about this is there's no burden on the news media to what they report anymore. So the burden and the only thing they can control is the court and agents of the court. That's the difference. In a footnote in the occurring opinion authored by Justice Brennan, I'm sorry. The following was noted: a significant component of prejudicial pre-trial publicity may be traced to public commentary on pending cases by court personnel, law enforcement officials, and the attorneys involved in the case. Shepard versus Maxwell, Supra, we observed that the trial court might well be prescribed extrajudicial statements by any lawyer, party witness, or court official which divulge prejudicial matters. The judge should have further sought to alleviate this problem of publicity that misrepresented the trial testimony by imposing control over the statements made to the news media by counsel, witnesses, and especially the coroner and police officers. You know, as I'm reading this, I'm thinking about, okay, I'm going to pause it. I don't know how much farther we got to go. Not farther. I'm going to pause it right here because I want to see what you guys are saying in the chat room. And then I'm going to continue this. I'm going to go all the way through it. We're almost done. I find this very educational. I hope you are too. But as I'm going through this, a thought came to me. And if those of you that are just tuning in, we're going over the paperwork that just dropped from Ann Taylor, and this is on the Idaho 4 case. And this is the gag order. Somebody asked me at the beginning of the broadcast, have we found out about the gag order yet? And then boom, in the middle of the broadcast, we found out that the paperwork dropped, and then we got it. I had a tornado outside, got hit by lightning and knocked my mixer off, knocked me offline. I'm back now. But the first part of this, we're going over wild ass speculations and wild ass theories about the Idaho 4 case, and then we're hitting the other true crime stories that are currently going on right now. And Justin came up again. And one of the things Justin said was that his father was a what? His father was a what? But you're almost, let me see. Do I even, yes, I do have his videos. His father was a deputy. I'm sorry. I'm going to go back to this. His father was a grand knight, and we're going to go back to the paperwork. And we're like, what the hell does this mean? And I was talking to everybody in the audience. I was talking with everybody in the audience. I'm like, what the hell does this mean? And
I need to show you guys something.
This is hilarious.
I need to show you guys something.
Show me. Show me, big boy. All right. All right. So somebody, again, I admitted, what the hell is this Charter Deputy Grand National Grand? Now, what the F does this mean? I don't know. I'm ignorant here. Somebody came in the chair and were like, what the hell is this guy talking about? And this is after we'd moved on in the show and they were rewatching it up to the point. And they're like, that just means that, you know, he was a fundraiser. He helped, you know, raise money for the children. I thought that was hilarious. My point is this. So the first part of the show, you're going to see this. And if you're watching the show and you're looking at the chat room, then you can see what's going on and what this guy's talking about. So you get some information, you don't know what it is, and you just make stuff up. I mean, how hard is that? Here we go.
My dad was a deputy grand knight. My father was a deputy Grand Knight. My father was next in line to be the Grand Knight. Someone shut my father up. My father knew something he wasn't supposed to know.
He was a fundraiser in the hospital.
If you knew my father, you have some serious explaining to do. Everything I thought I knew about my father has been a fucking lie. All of it.
I thought he was horrible, but he raised money for the children.
My father was mixed up in some shit, and someone needs to start talking.
I'm sorry I had to play that again. He was a money raiser. He was a fundraiser. All right, here we're back. That was just a side note. We're going through this information. We got a few. I'm going to make me a badge with crayons. That's what we do here. I could read this in the style of Jimmy Stewart. Well, as court officers of the court personnel and attorneys have a fiduciary responsibility to engage in public debate that will redound to the detriment of life of the accused, or that will obstruct the fair administration of justice. It is very doubtful the court would not have the power to control release of information by these individuals in appropriate cases, and to impose suitable limitation whose transgressions could result in disciplinary proceedings. All right, here we go. Shepherd and Nebraska Press leave no doubt that in appropriate cases, the court has the authority to regulate the speech of attorneys involved in a case, as well as their agents, such as law enforcement, to prevent prejudicial pretrial statements, to preserve the right to fair trial by an impartial jury. In 1985 and 1986, the Ninth Circuit Court of Appeals addressed a situation strikingly similar to the one now before this court in two separate opinions. As a way of background, defendant Richard Miller, a former FBI agent, was charged with espionage. The case received extensive local and national media coverage. After attorneys for both the prosecution and the defense engaged in extrajudicial statements to the media, the trial court entered an order prohibiting all attorneys in the case from making any statements to members of the news media concerning any aspect of the case that bears upon the merits to be resolved by the jury. In Levine, the court addressed a challenge to the non-dissemination order brought by defense counsel. The court framed the issue as addressing the clash between the basic and fundamental right to fair criminal trial, jury trial, and the First Amendment right of attorneys to engage in free speech. In reviewing the restraining order, the Ninth Court noted that the district court's order applies only to trial participants. The Supreme Court has suggested that it is appropriate to impose greater restrictions on the free speech rights of trial participants than on the rights of non-participants. The case for restraints on trial participants is especially strong with respect to attorneys. The court, nevertheless, applied strict scrutiny. Accordingly, the district court's order may be upheld only if the government establishes that 1, the activity restrained poses either a clear and present danger or a serious and imminent threat to a protected competing interest. 2, the order is narrowly drawn, and 3, less restrictive alternatives are not available. Internal citations omitted. The court concluded that the speech of the lawyers did pose a serious and imminent threat to the administration of justice and that the trial court's choice of remedy was appropriate. However, the court found that the non-dissemination order was overboard and directed the district court as follows. It is apparent that many statements that bear upon the merits to be resolved by the jury present no danger to the administration of justice. After the filing of this opinion, the district court must determine which types of extrajudicial statements pose a serious and imminent threat to the administration of justice in this case. The district court then must fashion an order specifying the prescribed types of statements. With regard to statements by the prosecution, it would be appropriate for the district court to order the government to observe the self-imposed limitations set forth in 28 CFR 1984. With regard to statements by the defense, it would be appropriate to prescribe statements relating to one or more of the following subjects. After this, guys, after I finish reading these next few pages, I have some information, some breaking news about Chris Cuomo. I know you're not going to want to miss that. It's actually interesting what he talks about when he lets his hair down. The character, credibility, or reputation of a party. 2, the identity of a witness or the expected testimony of a party or a witness. 3, the contents of any pretrial confession, admission, or statement given by defendant or that person's refusal or failure to make a statement. For the identity or nature of physical evidence expected to be presented or the absence of such physical evidence. 5, the strengths or weaknesses of the case of either party. And 6, any other information the lawyer knows or reasonably should know is likely to be inadmissible as evidence would create a substantial risk of prejudice if disclosed. ABA, Standards for Criminal Justice, Moral Code of Professional Responsibility, 1979. The case then went back to the trial court. The trial court amended its restraining order to adopt the 6th categories of speech by lawyers specified in the 9th Circuit as appropriate to prescribe. The Radio and Television News Association then filed for a writ of mandamus with the 9th Circuit, arguing that the restraining order, even as amended, posed an unconstitutional prior restraint infringing freedoms of the press. Circuit addresses the media's challenge in radio. Like here, the media argued that the order, by effectively denying media access to the trial participants, constitutes an unconstitutional restraint on the media's ability to gather news. Much of the court's opinion concluding that the trial court's amended restraining order was reasonable and served a legitimate purpose is worth repeating. The impact on the media in this case is significantly different from situations where the media is denied access to a criminal trial or is restricted in disseminating any information it obtains. In contrast, the district court's order in this case is not directed towards the press at all. On the contrary, the media is free to attend all of the trial proceedings before the court, the district court, and to report anything that happens. In fact, the press remains free to direct questions at pre-trial counsel. Trial counsel simply may not be free to answer. In sum, the media's right to gather news and disseminate it to the public has not been restrained. As we noted in Levine, the district court's order raises a freedom of the press issue that is analytically distinct from the issues that were raised in Associated Press and CBS. Rather, the RTNA asserts a First Amendment right of full access to trial participants. The assertion is not supported by constitutional case law. Procurner 1974, in holding that freedom of the press was not infringed by government restrictions on interviews with prison inmates, court rejected media assertion of rights of access to the sources of what is regarded as newsworthy information. The press does enjoy a constitutional interest in access to our criminal courts and criminal justice processes. Let me see how many. Holy God, this is long. Let's go back. Let's go down. I thought I could do it, guys. I thought I could do it. Let me check in with the chat room real quick. What do we got going on, guys? There are cameras everywhere. There are cameras everywhere. Even if he was home alone, they could probably prove it. I'm missing some good comments, guys. I know it. The Grand Knight confers with the Deputy Grand Knight and trustees and submits a recommendation to the ordinary of the diocese for appointment of a priest or bishop as a council chaplain. That is hilarious, guys. Yeah, that's right. I was thinking it was like collecting money in a Catholic hospital. Oh, man. See, you got to watch the chat room when people are watching these things. So Justin is just completely and utterly full of crap. Thank you, Dragonfly. Thank you, thank you, thank you. All right. So those of you that are wondering what the hell we're talking about Grand Knight, you'll have to watch the first half of this video, part 1. Who mentioned Freemasons earlier? I don't know. Somebody didn't say it was the Freemasons. Was it the Freemasons? All right. So continuing here, I'm going to see what message I got. We're going to continue on here. All right. Here we go. Boom. Comment 1. Rule 3.6 also expressly allows lawyers participating in a matter to state the following. 1. The claim, offense, or defense involved, and except when prohibited by law, the identity of the persons involved. 2. Information contained in a public record. An investigation of a matter is in progress. The scheduling or result of any step in litigation. A request for assistance in obtaining evidence and information necessary. 6. A warning of danger concerning the behavior of a person involved when there is reason to believe that there exists a likelihood of substantial harm to an individual or to the public interest. 7. In a criminal case, in addition to subparagraphs 1 and 6, the identity, residence, occupation, and family status of the accused. If the accused has not been apprehended, information necessary to aid in apprehension of that person, the fact, time, and place of arrest, and the identity of the investigating and arresting officers or agencies in the length of the investigation. What the hell is different with Idaho than the rest of the freaking United States? That is the question. Are they a shining pillar example of the legal profession? Only there, nowhere else? Because if you noticed, I went over several other true crime stories, and you knew every damn thing about them before they went to trial. What's the difference? We have videos of them getting arrested, the body. They don't care. They give you everything. What the hell is different here? And they're telling us it's not different. It's just the way it is. That is my problem. All right. I have no problem with what they're saying here. If these are their own rules, this is our rule that we established here. We're going by our own rules for this. I don't give a damn about their rules. Those are for them. Again, they're not for the media anyway, so I really don't care. It's for, unfortunately, the people that have the most problem with it are the mainstream media and the family and the attorney for the family. That's mainly it. Comment 1 to Rule 3.6 recognizes difficulty in striking a balance between protecting the right to a fair trial and safeguarding the right of free expression. Preserving the right to a fair trial necessarily entails some curtailment of the information that may be disseminated about a party prior to trial, particularly where trial by jury is involved. All right. So what I showed you is what was released by the different departments today about the Chad, the jackass in Ohio who killed his children. All right. What do we see? They gave us the 911 call. Do we have the 911 call from Idaho? No. Which is a bigger story? How come we don't have the 911 call from Idaho? What's different? It's like they're pissing on my face off the top of a building and telling me it's raining. They can say what they want. They're going by their own rules. What's the difference? We got the 911 call. We have the body camera of the video from the police arresting him. What is different with Kohberger? What is different? This other man hasn't gone to trial. Not just that, but these other stories I'm covering, I got some more I haven't gone over with you yet. What is different? That is what bothers me more than anything out of this. Now, you can tell me that it's normal all you want, but we know what we see. We weren't born yesterday. If we had no experience in this, and maybe some of them actually believe this because they've been in Idaho their whole life and they don't look at these stories on a daily basis like we do. We know it's not normal, so stop telling us it is. The American Bar Association has also standards for conduct of attorneys. Standard 8.2.1. Again, this is for attorneys. But I'm talking about the information that was released. Whether they have control of the attorneys is something completely different. When you're licensed, when you get a license, guys, and I'm not talking about a driver's license, although that does apply. You can't just drive get a license for a car and try to drive a semi. You can't do that. I have all kinds of licensing for broadcasting. There's certain things I do and certain things I can't do and certain things I shouldn't do. And then there's some gray areas, I have a special license so I can cuss, in case you're wondering. We are broadcasting over the airways right here in beautiful Badlands of Texas. For those of you that can get my signal. But whoever falls under that license, they have control of. And the media is something different. And media licensing is different also. Media licensing is one of the most, what's the word for it? Free licenses that you can get. Subject to any additional limitations imposed by local or professional rules during the pendency of a criminal matter, a lawyer participating in that criminal matter should not cause to be made, condone, or authorize the making of a public extrajudicial statement if the lawyer knows or reasonably should know that it will have a substantial likelihood of influencing the outcome of that or any other related criminal trial or prejudice the jury, even if an untainted panel ultimately can be found. Unnecessarily heightening public condemnation of a defendant or person or entity who has been publicly identified in the context of criminal investigation or of a witness or victim, or of undermining the public's respect for the judicial process. ABA standards for criminal justice, fair trial, and public discourse. I'll tell you what, their legal aids are real busy on this. While only the occasional case presents a danger of prejudice from pretrial publicity, this case is recognized by the Idaho Supreme Court, has drawn widespread publicity, garnering worldwide media attention and much speculation. Therefore, pretrial publicity does not present a real danger of prejudice. I'm sorry, did I say does not? Pretrial publicity does present a real danger of prejudice. In RE, petition for writ of mandamus, of writ of prohibition. Idaho, April 24th, 2023, recognizing the high-profile nature of the case and the extensive coverage it has received, along with the need to minimize possible pre-trial prejudice, the parties stipulated to entry of the original non-dissemination order and the amended non-dissemination order, as was noted by District Judge Stephen W. Boyce of his memorandum decision and order prohibiting video and photo. Okay, here we go, guys. What kind of video are we going to give the trial? And this was Idaho 24, April 24, 2023. As was noted by District Judge Stephen W. Boyce in his memorandum decision and order prohibiting video and photographic coverage in the case, of Lori Noreen Vallow Daybell. Agreement between the state and defense on any issue in a capital case is rare, further confirming to the court the legitimacy and level of concern counsel have raised. The same is true in this instance. Oh, this is bullshit. All right, so I do not agree with them on this. Yeah, they prohibited everything from Lori Vallow's case in the courtroom because the news media that were in the courtroom were doing illegal things. You know, Lori was making notes and giving it to her lawyer, and they were zooming in on it and trying to get audio of them talking together, which was illegal. So that is why they got kicked out, and that is why the defense and the prosecution was in agreement. It has nothing to do with what they're talking about here. One, this court has an obligation to take measures to ensure Kohberger's right to a fair trial, including prescribing potentially prejudicial, extrajudicial statements by any lawyer participating in the case. Few, if any, interests under the Constitution are more fundamental than the right to a fair trial by impartial jurors, and an outcome affected by extrajudicial statements would violate that fundamental right. The court also recognized the important role the press plays in the judicial system. Sure you do. A responsible press has always been regarded as the handmaiden of effectual judicial administration. Again, they've said this before, and they're saying it again, especially in the criminal field. How many? However, with the advent of the internet and social media, with the internet sleuths like you, the tensions between the First Amendment and the Sixth Amendment continue to increase. It's your fault. If you're watching this, it's your fault. As was outlined in Shepard, trial courts must take strong measures to ensure the balance is never weighed against the accused. In this case, the amended non-dissemination order in place by the party stipulation to protect Kohberger's right to a fair trial is not directed toward the press at all. Like in radio and television news, the amended non-dissemination order is aimed at attorneys participating in the case and their agents, such as law enforcement. The U.S. Supreme Court has made clear that a trial court can prescribe extrajudicial statements by any lawyer, party, witness, which includes the Gonsalves family here, party, witness, or court official, which divulge prejudicial matters. All right. Such restraining orders raise a freedom of the press issue that is analytically distinct from the prior restraints on the media. Non-dissemination orders that restrain the speech of lawyers representing clients in pending cases may be regulated under a less demanding standard than that established for regulation of the press in Nebraska Press Association versus Stewart, 1976. You guys, there's going to be a test about this. 4 pages left. Checking back in with our chat room right now. What do we got, guys? I don't know about any naked man, just my hubby. You didn't know I was going to read that one, nor did you know I was going to sing about it. Lisa Maxwell, correct. He has not given an alibi. He wants an extension. Yes, he does. I have no raw evidence. The case with the 3 kids had witnesses. Idaho 4, there were no witnesses. So this case is going to be harder to prove. Somebody's husband is running around naked as we speak. And then people are hearing about it on YouTube, and they're hearing about it on the radio here in the Badlands of Texas and around the world. 360 degrees around the earth. Boss, Maca, Laura, from my own experience and observation, MPT are the biggest thugs in Moscow that are capable of doing a crime like this and getting away with it. Always good to hear from Boss. Electra, I agree, although he is the only man, woman on this planet that could have placed that DNA on the sheath. You know, to speak about that, so you guys have heard that the DNA came back, the cheek swab on Kohberger, and they said it does match the sheath. Before what they had, so they took what they had on the sheath and they matched it with Kohberger's father, saying there was a 99 percentage that a child of Kohberger's father is the one that touched the sheath. All right. Which leads you to believe that, hey, maybe that means the murderer could have been one of Kohberger's sisters, right? Ha ha. Just thinking in your mind, well, technically it could be one of Kohberger's sisters. Check this out. So it's epithelial. Somebody asked, is sweat and epithelial cells is what they had on the snap of the sheath. And man, there couldn't be a less amount, just like a little swipe on the sheath of the fingerprint. Check this out. Whenever you're doing a DNA analysis, they always have to do 2 samples, right? And we're talking about a little swipe on a button. Like right now, I'm not going to show you because it's kind of gross, but when I was busting ass through the house trying to run away from the tornado earlier after it zapped my mixer and knocked me off the internet, I got a little fingerprint here on my glasses, just a little fingerprint. I don't know if you can see it. I know you can't. So you're taking this little bitty epithelial cells, which is the hardest thing to get DNA from. You got 2 samples that you have to send off for 2 checks for the father. Then you have to do 2 checks from that for Kohberger from just epithelial cells from a fingerprint. That's hard to believe. It's not like they had blood, or did they? So yeah, I find that highly suspect, and I really want to look at that evidence because I'm not saying it's not true, but I'm saying epithelial cells. They did 2 samples of it to check the hereditary DNA from the father's trash, and then they had to do 2 samples for Kohberger's cheek. All right, what else do we got here? Dragonfly. They went to the girl's house enough, and Laura and Electra, for noise complaints that the one took a picture of her ID with the cell phone as body cam. That is true. That is true. Naked in the middle of a tornado on a Fruit Loop freaking Friday. That is something right there. What if MPD confiscated the sheath during the 821 interrogation with BT? I was thinking about that. So I was thinking, and again, I'm going to finish this. We got 3 or 4 pages left. And we're reading over the papers that came back about the gag order today. What other scenarios would be legitimate for his fingerprint to be on that sheath, to be in the house? Now, not necessarily where they found it on the bed, or for somebody from the Greek fraternity to have it. What scenarios could have existed for that to actually have happened? If he was, there would have to be a level of planning. If he's there smoking a doobie and somebody throws the knife in a sheath, hey, jackass, catch it, and he catches it. Hurt. If they planned it ahead of time, that would happen. Somebody knew him there, actually knew him. If he'd actually been in that house before many times, like if there really, and I'm not saying there was, again, this is a speculation. It's not even a speculation because I'm not saying it's true, but if he's in the house before, he was in there many times, it was a drug house and it wasn't that big of a deal, and he was in there, that could very well happen. Someone's saying, Sheath not planted, in my honest opinion. I don't know. I don't think it was planted either, but actually, that's not really even saying it's planted. And proving that something was planted, yeah, how is that ever going to work? There's some people, I was looking at these wild ass speculations, and there's some people that swear that he didn't do it. There's some people that really think that, and they don't have a lot of information, concrete information backing it. But proving that DNA was planted would, if it was, don't you think that would almost be impossible to do that? All right, continuing this right here. have a fiduciary responsibility. Oh, wait. I saw a good comment. They planted stuff on Steve Avery. That's what somebody said. They planted stuff on Steve Avery. Yeah, I saw that documentary too. And I don't know what all they planted, but one thing I saw that did look like it was planted is it looked like that one officer planted Hallbach's burnt out car, or her car. It wasn't burnt out, in Stephen Avery's property. That did look like that happened. But again, like I said, whether they planted it or not, it's really hard to prove that somebody planted something. You know what I'm saying? Not saying that they did or didn't. You know, it looked like they did to me when I watched the documentary. But again, court of law, that's hard to prove that something was planted. Let's look at that. What's the statistics on saying, hey, it was planted, and then actually saying, well, you know what? These men that work for us, these fine, upstanding police officers, you know, I'm looking through their record, and Mr. Criminal man we're accusing, you're right, we're going to side with you. They don't do that, man. I mean, I'm going to continue this. Non-dissemination orders that restrain the speech of lawyers representing clients in pending cases may be regulated under a less demanding standard than that established for regulation of the press. All right. Membership in the bar is a privilege burdened with conditions. Again, they said that before. 2, strict scrutiny does not apply to the media's constitutional challenge of the amended non-dissemination order. And 3, the restrictions on the extrajudicial statements of counsel and their agents to the press are necessary to reduce prejudicial publicity and protect Nothingburger's right to a fair trial. And 4, do we have a 4? All right, let me see where the end of this is and read the last 2 pages. Here we go. I hear the storm coming back. The evidence presented by the defense shows that 1, media coverage in this case is rampant and ongoing. At least one, if not most, of the news coverage is prejudicial to Kohberger. 3, a portion of the statements being made to the media are coming from an attorney participating in the case. And vacating the non-dissemination order would increase the potential for bias among prospective jurors, both initially and throughout the trial. And 5, anti-defendant pretrial publicity increases the probability of guilty verdicts, and then this bias persists despite the receipt of trial / argument / evidence, admonitions, and disregard of the public information and jury deliberation. Commentary by individuals with status / expertise, police, attorneys, and judges, and media coverage create a more potential for biased jurors. Example D, to defendant's objection to media's to vacate the amended dissemination order. As currently drafted, the amended non-dissemination order is arguably overboard and vague in some areas. However, it does not serve a legitimate purpose, and restricting the speech of attorneys participating in the case is reasonable. The very incidental effects of the speech restrictions on the media's First Amendment rights are overridden by the compelling interest in ensuring a fair trial by an impartial jury. Statements by counsel participating in the case on matters bearing on the merits of the case might impair the fairness of the trial or threaten the integrity of the judicial process. The amended non-dissemination order is not intended to conceal the workings of the criminal justice system from the public. Of course not. The media is not restrained in any way and is free to attend hearings and report on what they observe and hear. For these reasons, the media's request that the amended non-dissemination order be vacated is denied. Pff, off with you. Go eat cake. However, because the amended non-dissemination order is arguably overbroad and vague, the court will issue a revised amended non-dissemination order to further clarify and narrow what speech by lawyers participating in the case and their agents are allowed and prohibited by giving specific examples. The revised amended non-dissemination order is narrowly drawn to prohibit only extrajudicial statements that have a substantial likelihood of materially prejudicing the case. The restriction on attorney speech applies equally to all attorneys participating in the public case and will restrict the attorney's comments only until after the trial and any sentencing proceedings. The regulation of attorney speech meets the less demanding standards set forth in Gentile or Gentili, either way it's spelled like that, as well as strict scrutiny. The restrictions are necessary to protect Kohberger's right to a fair trial and the fair administration of justice. By golly, we shall have justice. As to the media's constitutional challenge, the restrictions imposed on attorneys participating in the case and their agents are not only reasonable and legitimate, considering the high-profile nature of this case, but also meet the strict scrutiny standard. The Associated Press requests that the amended non-dissemination order be vacated is denied. However, the revised amended non-dissemination order will replace the amended non-dissemination order. It will clarify and narrow the restrictions on speech and individuals whose speech is speech. Signed, Love, John C. Judge, District Judge. Read by Gerald Smimmons. 4. Audible. Yeah, I just did the audio book of this. All right, guys, let's see what we got now. Norma Jean says, come forward first couple of days saying he was on the bridge in the close at the time, so the guy walked free, working at CVS for years. You guys are talking about. I'm so excited. Indiana Jones, the new movie sucks. Indiana LA, sorry. I thought you were talking about the movie. All right, guys, I'm almost out of time. I'm going to see if I have any time for any of these stories that I missed. I'm going to have to go through real fast. Woman and ex-husband dead in apparent murder-suicide in Geneva.
We have new details of yesterday's deadly shooting in West suburban Geneva. Police say a man killed his ex-wife before taking his own life. Authorities say 49-year-old Chad Dockery called 911, informing them that he had murdered his former wife, 48-year-old Amanda Dockery.
Wow.
When police arrived, they found Chad.
Damn, that's a nice house, too.
Inside a vehicle with a self-inflicted gunshot wound. Both were taken to the hospital where they were pronounced dead.
Crazy. All right, moving on. Now, we talked about the aliens. All right. I don't have a lot of time to go over this, but I had the footage of the damn spacecraft. Yeah, I've got footage of the spacecraft. Here it is. Here's what they saw. This is of something falling, and this is not. Again, I'm telling you this, guys. This is bizarre shizzle McFizzle. All right. You can see the UFO or unidentified aerial phenomenon falling. This is not the backyard that it fell into. It fell into a backyard, and those are the people's. We saw that video. I'm not playing this whole thing for you, but I'm actually just playing the footage of the damn thing falling right now.
It was the streak seen across the sky. It was the streak seen across the sky, now seen around the world.
It went into a backyard.
It was the streak seen across the sky, now seen around.
I'm going to show you the streak.
It was the streak seen across the sky, now seen around the world.
Used to mean something else in the 70s.
This, as our 8 News Now investigators confirm, Metro actually set up cameras at this home where a family called 911 claiming to see aliens in their backyard. And tonight, a fierce...
All right. That's all I've got to say about that. All right, I'm going to check this out. I'm almost done, guys. Check this out. Chris Cuomo's letting his hair down. He says some unfavorable things about Sylvester Stallone, but I found this exchange very interesting. I'm going to play it.
Wolf Blitzer, I called the captain when I was there.
All right. So before I play this, I'm going to play what he said about Wolf Blitzer. So guys, what can you tell me about Wolf Blitzer? Apparently there's something I missed. Wolf Blitzer got fired for having his penis out underneath the desk. True story. What? I didn't know that. So Chris Cuomo has branded acting legend Sylvester Stallone a cartoonish fool in a bizarre rant during appearance on the Adam Freeland show on Wednesday. The disgrace CNN anchor 52, again, this is by Daily Mail. Apparently they don't like Chris Cuomo, so they're slanted. And when you see the video, you'll see how it actually went down. But he said he doesn't love any of his legendary characters, Sylvester Stallone. Now, here's when the chat began. This part is not on the video. The chat began when Freeland asked if his former co-worker, Wolf Blitzer, had ever had his penis out under the desk, to which Cuomo responded, no, I called him the captain when I was there. Okay. So, I don't know. Is that a thing that Wolf Blitzer used to do? I don't know, but here's this exchange, and then I'm going to move on after
Wolf
this.
Blitzer, I called the captain when I was there. He was the exemplar of everything we wanted to be. The guy works his ass off.
It's like a
and he's a
Stallone
good
character.
man. I know.
Wolf Blitzer.
Except instead of being a cartoonish fool, Blitzer is just an earnest.
You're
good
anti-Stallone?
guy. I don't love his characters.
So, Chris, I wouldn't hate anyone, okay?
You get easily offended, huh?
That last part I found was hilarious. Chris, I wouldn't hate anyone. You get easily offended,
You're
huh?
easily offended, huh?
I thought that was hilarious. I don't know if she's a girl. It's the name of this video. Check this out. You won't believe what she did.
So tonight, he thought he was on a date with a woman he met at a nightclub when he brought her back to his hotel room. But police say she had other plans in mind. NBC6 Claudia Docampo is at the Metro Justice Building with the details.
Well, it seems a date went horribly wrong when the victim says he was pepper sprayed and robbed.
Good morning, ma'am. You're being charged armed robbery with a weapon.
Prosecutors say 21-year-old Alicia Thalasinos met the victim at Club Space. Then they took an Uber to the Fontainebleau Hotel in Miami Beach and went to his room.
After entering the room, she grabbed $500 of cash from the nightstands. She went to leave. As she exited the door, he tried to get a hold of her to get the money back.
But instead, the victim says he got pepper sprayed. He then called the front desk, and Thalasinos was stopped by the hotel security officers as she was trying to get away.
She was detained. She had $580, I believe, in her purse, as well as the bottle of pepper spray.
How long have you been here, Miss Thalasinos?
For about 5 months now.
Okay.
Thalasinos has prior arrests in New York for allegedly stealing a car, and then in Pennsylvania for retail theft. The judge gave her a bond of $5,000 plus a stay-away order from the victim. At the Metro Justice Building.
Local singles near you willing to date. Did you guys see this? Check this out.
You're gonna need some time on yourself, baby.
Looks fake to me, but apparently McGregor knocked him out. At least McGregor knocked somebody out. Oh. All right, so I have this story. I'm not going to go over it, but teen arrested for murder of Florida grandmother who is a Desert Storm veteran, and this was a female. Angela Sutton was shot and killed February 7th near a strip mall in Orlando, Florida. The alleged shooter was a 15-year-old. Was charged with first-degree murder. So, yeah. This is just disturbing as hell. And I want to share it with somebody. I don't know what to think about this. Kirby.
Yeah, stop. How dare you ruin it for everybody else? Get out. No, you go. I'm not going anywhere, shithead. Get the fuck out of my neighborhood. Get out. You're no artist. Stop. You're a mediocre piece of shit. You can't even play. You suck. I've been playing 41 years. You suck. I'm a left-handed guitarist. You suck. No. you go. Get the fuck out. Get the fuck out. Get out. Fuck you. Fucking asshole. Get out. Where are you from? Where are you from? Go to a studio and rehearse. Maybe something you'll learn. You suck. You're a no-talent piece of shit. You oppose your lack of talent in order everybody around you and they want you to not. Get out. How dare you come down here and do this? I'm here 14 years. I've lived in this time my whole life. You're a disgrace. You suck. How dare you? I'm 3 blocks down. Who the hell do you think you are? Who the hell do you think you are? You any kind of artist? Anybody know who you are? Maybe everybody else wants to enjoy the peace and quiet. This is one of the most important places in all of North America. Who are you? Who are you? You miserable, presumptuous, no talent. You're no artist. An artist respects the silence. It serves as the foundation of creativity. You obviously don't have the talent. You don't have enough respect for yourself or other people, or in what it is to express yourself. In music or any other form of creativity. And I'm an NYU film school graduate, sucker, and the School of Visual Arts, and the Academy of Art University in San Francisco. You suck. You're a no talent. If you really had talent, go practice and then get yourself a gig instead of ruining the end of the day for everybody down here. You disgrace. You're everything that's gone wrong in this world. You're a self-consumed, no talent, mediocre piece of shit. And I've earned my right to say it. Okay? I had 200,000 people with Bill Graham. In 1975, I walked Bob Dylan up on stage. Who the fuck are you? I knew the Grateful Dead from 1966.
Is this Paul Simon?
Who the fuck are you? You nothing. You nothing. You are nothing. And you will never be anything. Never. How dare you? How dare you? You miserable, mediocre nothing.
I think I want to end every show of mine with that from not the whole thing, but just the last part from now on. All right. Let me see what else I got for you. Amber Bailey. All right. Thank you guys for tuning in. This is the second part where we went over all the paperwork from Idaho. Oh, there's Emma. Hello, Emma. She's eating pizza delivered by Gerald Schmittis. I'd like to thank you all for tuning in tonight. We're going to be back next time. Until next time, we'll let you know we're going to be on. So, you can go to our website, midnightred.io. Let's to our radio station down there. We got a lot of things going on and some updates. Let's see, there's a lot of people who have fallen off. I think Electra went to bed. She fell asleep on her computer, no doubt. I want to thank her for taking over for me while I was getting hit by a bad storm down here. We'll be back. If you want to email me, it's midnightrad.io101@gmail.com. Again, that's midnightrad.io101@gmail.com. You can call 325-261-0892, 325-261-0892. Leave a message up to 3 minutes long. Until next time, good night, God bless, and all my best.